The Amabhungane Center for Investigative Journalism is challenging South Africa's surveillance law known as Rica. Amabhungane launched the court action as it believes the act is being used to spy on journalists' phone communication. Right to Know and Privacy International are friends of the court. Deputy National Coordinator for Right to Know, Khalib Gallant, joins me now. Good evening, Khalib. Thanks very much for your time. Perhaps first you can tell us why you decided to join this application as friends of the court.
Good evening, and thank you for the opportunity. We believe that, as R2K, we believe that this is a really critical moment in our history. The main substantive part of the court case is about the spying on journalists and activists, and it's an important moment to highlight that for the public, but also to bring it before the courts. For us, there are four really important issues in this case. One is to highlight, I guess for us, the importance of the mass surveillance that has been happening outside of the bounds of the law. So even though we have the Rica legislation, much of the surveillance, mass surveillance that has been happening over the past decade or so has been happening outside of the framework of the law, and I'll maybe come back to that in a moment. But what Rica allows, and what we're challenging in terms of the constitutionality of Rica, is the mass retention of metadata, which, for example, says that my data and where I've been going today must be retained on the servers of my service provider for up to 5 years, and then is available for investigators without any protections for me for the duration of that 5 years. There's also no notification to me as an ordinary citizen that I have been surveilled. And so one of the key planks of our arguments is that where someone has been surveilled, like Sam Soul, for example, there ought at least to be post-interception notification. So once the investigation's been done and nothing has been found, at the very least, there should be some notification that I was at least suspected of having done something allegedly. So I think for us the importance of this case is to show just how much we are being surveilled, and and the extent to which that is happening behind a veil of secrecy. Our privacy is being invaded on a daily basis, on an hourly basis. Every email that you are sending has the potential for being read. Every WhatsApp message, wherever you're using any form of indirect communication, that is being captured and being held. And so we're wanting to get the legislature, get the state to roll back on that kind of breach of the right to privacy. To put in place, we recognize that there will be the need for some kind of interception, but that should be limited. Any breach of a constitutional right should be restricted. Any limitation on a fundamental right. Yeah.
Okay, I mean, you are aware of the Sam Soul case, but how widespread do you believe, abuse is? In other words, do you have evidence, or is it merely a suspicion given, just how technology is like these days?
So we have, Amabhungane did an expose probably about 5 or 6 years ago already. And certainly we've made submissions to the various ministers in 2016 and 2017. We have a national communications center outside of Pretoria that has been operating outside of the law since its inception. It has no basis in law for what it is doing, which is reading everybody's emails, It talks about foreign signals, but every time I send a Gmail, that goes to a foreign server, and then that seems to justify government being able to read and retain and analyze that information for many years. So that we know has been happening and is continuing to happen. That's the probably, I think, the most important part for us, at least in this case. But in March of this year, there was a high-level panel looking into state security that finally released a report. We pressurized the president to force that. And Right to Know was one of the organizations that State Security Agency admitted they'd been surveilling. There were a number of other organizations, many organizations that took part in the Zuma Must Fall movement that swept the country during the regime of our former president. So at the very least, in March, there was an admission by State Security Agency that they had surveilled and infiltrated many activist groups. We know, not just anecdotally, of journalists being targeted, phones being tapped, etc. There is sufficient evidence that has been happening. Rica is meant to be a regulatory framework. The framework, we are saying, is inadequate, including the judge, Judge Yvonne Mogoro, we hold in high esteem, but the office of that judge is not independent enough. And so whoever occupies that space will have some challenges. So the regulatory framework is not sufficient, we're arguing, and then it is just flouted on a regular basis by the security agencies. So much of this is happening also, you can appreciate, in the shadows. So the full extent of how much surveillance is being done, of course we won't have that information. That it is happening, we are absolutely sure of.
Okay, that's where we're going to leave it for now. Thanks very much for your time, Deputy National Coordinator for Right to Know, Khalib Galant. Of course, the Pretoria Court hearing that critical and long-awaited constitutional challenge to the regulation of interception of communications and provisions of Communicated-Related Information Act of 2002, otherwise known as Rica. Well, many of you only know Rica as, that law you have to comply with when you get a SIM card. Actually, it goes way, way beyond that. And for journalists in particular, it does pose a danger because it means if journalists come across information and they investigate, they get followed by the powers that be to try and thwart some of those investigations. No?